Why does the SCM agreement require that only measures that are financial contributions can potentially be subsidies and thus potentially be subject to the rules and disciplines of that agreement? This is an important question which was first dealt with by a dispute settlement panel some years ago. Recall that the definition of subsidies contained in the SCM agreement has four main independent elements. These are financial contribution, government or public body, benefit, and specificity. As an alternative to financial contribution, any form of income or price support also is potentially a subsidy. All four of these elements must be present for a measure to be covered by the agreement and thus subject to its rules. What does the financial contribution requirement do operationally? In essence, this requirement limits the types of measures potentially covered by the agreement to only certain listed forms. The first of these forms involves monetary transfers, which can be direct transfers of funds such as grants and loans. They also can be potential direct transfers of funds, such as loan guarantees, where the money would actually only change hands in the event of a default on the loan. The second form of financial contribution is the non-collection of revenue that otherwise would be due to the government. This could cover anything from tax exemptions and holidays to discounts or exemptions on government fees. The third form is the provision by government of goods or services, or the purchase by government of goods, so in-kind transfers. The fourth form is the payment by government into a funding mechanism. All of the forms of financial contribution have one thing in common. They all involve the transfer of something of economic value by the government to the private sector. So why did the Uruguay Round negotiators consider it necessary to limit the forms of measures that would potentially be subject to the multilateral rules on subsidies? Remember that before the Uruguay Round, the subsidy rules of the GATT, both in the GATT articles themselves and in the Tokyo Round Subsidies Code, contain no definition whatsoever of the term subsidy. Yet, since the beginning, the GATT system has imposed disciplines on the use of certain subsidies and has given its participating countries, in the old days the contracting parties, today the members, the right to impose countervailing measures on subsidized imports into their territories where those imports are causing injury. Before the Uruguay Round, there were very few disputes concerning the subsidy disciplines under the multilateral rules. By contrast, however, there were a relatively large number of countervailing duty investigations and measures, particularly by certain large trading countries. In this context, the question of what sorts of measures could be countervailed became extremely contentious, as each country implemented its own definition of countervailable subsidies. One country treated any formal enforceable measure that conferred a benefit to a private party, and thus could distort trade, as a countervailable subsidy. The focus of that country's countervailing measures, therefore, was on the effects of the government action, regardless of the nature or form of that action. Other countries focused in their countervailing duty investigations on whether a government measure involved a cost to the granting government. These big differences in national approach led to a number of GATT disputes over countervailing measures during this period. In many cases, the results of those disputes were never adopted by the contracting parties. Governments thus became increasingly concerned that their exports could be subject to countervailing measures or other measures purely on the basis of the economic effects of the government actions and without regard to what sorts of actions were involved. That is, without regard to the intrinsic nature of the action or measure. This meant in practice that countries had little or no guidance as to which of their measures were subject to their legal obligations and rights under the multilateral subsidy rules. When the Uruguay Round was launched, negotiators therefore gave high priority to drafting a definition of the term subsidy that would clarify for all members the scope and coverage of the multilateral rules on subsidies and countervailing measures. By focusing on the form of the measures as the first element of the definition, and limiting this to transfers of certain things of economic value, the negotiators provided clarity to governments as to which of their measures could potentially give rise to subsidies for purposes of the multilateral rules. In particular, by introducing the concept of financial contribution, and by listing the forms of financial contributions, the negotiators ensured that it was no longer possible to treat measures as subsidies solely on the basis of their economic effects. This greatly enhanced the transparency and predictability of the multilateral rules on subsidies and countervailing measures. Thank you.